So we're now going to invite our next guest speaker, Mr. Bongani Luthuli, who's an admitted attorney. He graduated at the University of Johannesburg with an LB degree and further obtained a postgraduate diploma in corporate law specializing in the Companies Act in 1998. He's a contributing analyst to the Thinker magazine, a Pan-African thought leadership publication, which is edited by Dr. Esau Pahad, his former political mentor. He publishes mainly on issues of labor law and industrial relations. Ladies and gentlemen, let's please welcome Bongani to the podium. Thank you. Thank you so much.
Hello, good afternoon. It is an honor and a privilege to speak today. I'm particularly grieved that I would be asked to speak next to, or after Mr. Vavi. It's literally a tall order. But thank you so much for taking some of the time. In any event, my discussion is quite brief today, so that really assisted. Well, my topic for today is quite crisp and very brief, entitled "The Doctrine of Inconsistent Application of Discipline, Our Boundaries Stretch Beyond Breaking Point." And I think what you're going to get here is more of a grievance, as it were. It's a complaint that I have personally, and I'm taking you through the streams of my consciousness on an established and tried legal principle that I feel quite hinders a lot of progression labor-wise, especially in the economy. And I say this with boldness because my practice has taken me through Africa with all humility, and you find a market like in Kenya where they literally have contracts in which you contract yourself out of referring a matter, and that has helped in terms of that system being liberal. And even though ours is quite rigid, thanks to the marriage between government and the union, we can't have that system. But some lessons can be taken from there. CCMA itself is quite full of cases, some of them which could be sifted out if a similar approach were to be adopted. So I start with asking this question: should administrative arbiters and courts concern themselves with discussions outside formal process of disciplinary hearings to determine consistency of discipline? And this becomes important because when we talk about the doctrine of consistent discipline, we're not talking about sanction. We're talking more what is the process that's been followed before even you get to the sanction. I have this unfortunate displeasure of being involved in disciplinary hearings that are protracted for about 12 months. I don't know whether most of you would understand, and it has huge legal implication. At some point, the companies can get out of pocket, even employees can get out of pocket. So when we use this doctrine, at least in the manner in which could be flexible, one could see some progress. And I ask further, what then when the proceedings have become protracted, somewhere in the line, parties, as often is the case, decide, look, we want to enter into discussion around separation agreement. Can that discussion that happens during the hearing itself amount to inconsistency when another employee comes and says, whoa, but you have actually acted inconsistently because even though my hearing went on, you did not offer me a separation agreement or an opportunity to resign. And this is quite fundamentally an epistemological point that we as labor practitioners need to deal with, as it were. Our reasons proffered for treating a comparator and establishing consistency relevant as a determining factor in light of the nature of such discussions, which are usually without prejudice. And here's another what philosophers, jurisprudential philosophers call the penumbra. That's the issue. When you deal with a comparator, those discussions that happen around voluntary separation, around resignation opportunities, are by their nature without prejudice. So the question is, at what point do they become an issue of inconsistency? Is it the mere act of offering, or is it the content that's discussed within the without prejudice discussion? And I feel, because I think already you know where my standpoint is on this topic, I feel that it may very well be the content, the substance of the discussion as opposed to the act. If we are going to talk about expeditious resolution of disputes, which I argue doesn't come from a dispute resolution, whether it's bargaining council, CMA, it may very well start from as early as the internal disciplinary hearing. The doctrine, as we all know, stems from Schedule 8, Item 7 of the Code of Good Practice. Any person determining whether a sanction, whether a dismissal for misconduct is unfair, should consider if a rule or standard was contravened, and here's the doctrine that's premised here, whether or not the rule or the standard has been consistently applied by the employer. That's where we find the doctrine comes from. There are two types of inconsistencies. One, we have the historical inconsistency. I must apologize for the slides. You can see that it was designed by a reluctant 21st century practitioner who refuses to come to 4IR, but just bear with me. The historical inconsistency, that's where a number of employees have committed the same act of misconduct at different times but have not been measured by the same standard. It's often common that employees will say, well, you treated employee X differently. Why are you treating me this way? That's quite known to us. Then you have contemporaneous inconsistency. This occurs when a number of employees have committed an act of misconduct at the same time but are not treated the same. Again, you have I've recently encountered where you have a mess hearing, where, for instance, employees have participated in an unprotected strike. How do you handle those employees? Do you discipline them all en masse? Or can you have an opportunity to discuss with others, offer others resignation to maintain their clean disciplinary record because it haunts them post-employment with this particular employer? Or do you just put them all as one egg in a basket? The presentation deals with contemporaneous inconsistency as a species of inconsistency. The two do intertwine. Sometimes the historical as well as the contemporaneous does intertwine. So what does really consistency refer to, as I alluded to earlier? It refers to the procedure followed, not the sanction. And I had to learn this the hard way in my early practice, and I'm not that old, that as I was passionately arguing that you gave this employer a final written warning, but you've now dismissed my client. And I thought that was what was mentioned by inconsistency. Because if that was the case, then the question then is, what role would personal circumstances play if we are, and also bearing in mind that disciplinary codes are not cast in stone. They are a guideline. And therefore, if you dismiss this employee on a same or similar offense, doesn't necessarily mean that you can dismiss the other. So the prompt question then we need to grapple with is, does the failure of an employer to give an employee an opportunity to resign and maintain a clean disciplinary record amount to inconsistency of discipline where it had provided such an opportunity to another employee charged with the same offense? And I must pause here to reflect, because this is where, personally, I have an issue. The notion of an opportunity to resign seems to me to create some level of absurdity, because does one really need an opportunity to resign? If resignation itself is a unilateral act that does not need to be accepted, why are we making and paying too much lip service on an opportunity to resign when, for all intents and purposes, it is freely available? Are courts not making too much of this from the doctrine's point of view when the contract of employment is based on the concept of freedom? You are free to contract and you are free to come out. So then why are we paying too much lip service and carry too much weight when we say people that have been dismissed for failure to be offered an opportunity to resign becomes a substantively unfair dismissal? In Capitec Bank versus CMA, this was the very issue that this matter. I see Natasha is smiling. This was the very issue that was there. And in that case, the facts are derived from an extemporary judgment, so they'll be cursory, just as the nature of extemporary judgments are. Capital had ruled that when an employee issues or approves a loan who has submitted fraudulent documentation, appropriate action to be taken warrants a dismissal when fraud check was not properly done, and as a result, errors or fraudulent indicators were not detected. The employee in question was charged with approving a fraudulent loan, which was issued by another colleague, P. As you know, in the banks, there will be that vetting process. Everybody is involved on the granting of the loan, from those who do the initial fee cut to those that actually sign the transaction off. Now, Capitec suffered a loss of 79,485 rands during this fraudulent transaction. The employee pleaded guilty, expecting not to be dismissed. I'm not sure whether she was represented by a trade union, because I've seen my colleagues on the trade union side, that the advice seems to be standard. I say that tongue-in-cheek, Mr. Favre. It seems to be standard. Plead guilty, plead guilty. You will not be dismissed, as though that is, that is a given. And some of our colleagues as well do give that advice. And so that employee was actually advised, plead guilty, and you will not be dismissed, because that remorse itself is enough to actually flip the script and you get discipline or sanction short of dismissal. Sadly for her, she was dismissed. But at the hearing, she raised an inconsistency argument based on about 3 employees. One was G, who issued a fraudulent loan of 1,500 but was not dismissed. The other was K, and then there was the commissioner, Commissioner Charles Oak, who's well known to me, and I call him by name because he's been a happy hunting ground for me. Commissioner Oak found, and quite correctly so, that as a distinguishing factor, K had a disciplinary record, and for that reason she was not disciplined. But given the option to enter into a separation agreement or to resign, but she was not disciplined. But when it comes to this particular employee, the reason why she was not given an offer, an opportunity to resign, was because she was said to have a disciplinary record. But the problem is, factually, she has a disciplinary record, she's got a history, but legally, these records have expunged. And legally, these records have expired. So here you have another conundrum where the employee, well, the employer feels that there's a valid warning, but the commissioner and subsequently the court feels that the reliance of this warning was not enough as a distinguishing factor because it is not valid. But do you have that legal advice at the hearing level before you get to the CCMA, where the validity of the warning is actually discussed? This was quite interesting because even the final written warnings were not even related to the offenses. Now, the commission found that there was no difference between employee K, and because both had a disciplinary record. So the fact that the warning itself was not valid, automatically the failure to give this employee an opportunity to resign rendered this dismissal substantively unfair. The court placed reliance on Executive Council, Department of Health, Eastern Cape, which found that one of 3 perpetrators, that's the commissioner rather, that one of 3 perpetrators involved in the same transaction were given opportunity to resign, but a third one in a similar position was not given the opportunity to resign. For that reason, it was held to be substantively unfair. The Labour Court, it found that of the 4 employees issued, checked and verified the documentation, only 1 was dismissed. And that 1 employee was not afforded an opportunity to resign. And then therefore, Capitec should have made an offer of resignation to enter into a mutual separation. Executive Council was upheld as being applicable, and therefore Commissioner Oakes, to his credit, his award was said to have fell within the ambit of reasonableness. But some thoughts that I ask in rhetoric is, what is the effect of inconsistency in this context where the offer and discussions are made without prejudice? There's something to ponder on, and that's exactly what I had started with. And employees have an option of resignation, as I said in my opening remarks. That is a unilateral act. And why, therefore, such a seemingly academic exercise? And I say it's academic respect because it's just naturally available for you at your disposal, have such a substantive consequence. A little bit of a practical advice: avoid affording employees an opportunity to resign across the board so that you just avoid falling trap of this inconsistency issue. Otherwise, insert a clause in a discipline code that will state that as a matter of principle, either you will offer resignations or you will not, pending a disciplinary hearing. I thank you.
Bongani, any questions for Bongani? Any questions? Okay, Bongani, I have a comment, and I'm just interested to hear what you have to say about it. So is our court equating resignation to discipline? Because my understanding of inconsistency is that it's relevant insofar as the rule is concerned and the sanction is concerned. So is our court now saying that a resignation, if an employer offers an employee a resignation, now that is offering, that is, it's equating it to a sanction and a rule, to discipline?
All right. It's consistency argument does not have to do with the sanction.
Oh,
The procedure
Sure.
leading up to the process.
I see.
Yes,
Oh, it's the
so the act of
procedure.
resignation is not so much the issue. The issue is the offer to resign, to salvage your clean disciplinary record, which boils around consistency.
Oh, okay, I get it now. Okay, all right. Thank you so much for that explanation. Thank you so much, Bongani. Okay. Thank you so much, ladies and gentlemen. We're now going to move back to Galetic for our keynote address, right next door.